Welcome, everybody, to Legal Tech Week for February 23rd, 2024. This is the show where we talk about the stories of the week in legal tech and innovation. We weren't here last week because a lot of us were off at ABA Tech Show. I think actually all of us were off at ABA Tech Show that are on the panel today. So we're going to talk a little bit about that and other stuff out of the week. I am Bob Ambrogi. I have a blog called Law Sites and a podcast called Law Next. We've got one guest panelist today, Julie Shabwale. Julie, why don't you introduce yourself?
Hi, everyone. I'm the token Canadian today. My name is Julie Shavwali, and I'm a legal journalist. I write for the Canadian Bar Association and Canadian Lawyer.
It's always good to have occasional Canadian on the show. Yeah, just to bring some sane perspective to things. And also joining us this week, Victor. You want to go next?
Hi, everyone. My name is Victor Lee. I am Assistant Managing Editor for the ABA Journal. I am not Canadian. I've always liked Canada whenever I've gone, though. I think the last time I went was a while ago. I went to Toronto. So I don't, yeah, but yeah, I had a blast and it was a lot of fun.
And Steve?
Hi, I'm Steve Embry. I write the blog Tech Law Crossroads. I was also on the Techshow board this year. So if anything good to say it to me. Anything bad, you can, keep it to yourself, whatever. Glad to be here.
And you're going to be cheering Tech Show next year, right? Or do we know that, or is that not a thing?
We don't know. That typically is what happens, but we do not know that as of yet. There's still time for me to screw things up, I guess.
All right, we hope so. And last but not least, Joe.
Joe Patrice from Above the Law and Thinking Like a Lawyer. I am on the road yet again, but glad to go from one tech show to another tech show to another conference. But so I'm getting tired, but the end is in sight.
Yeah, and I guess Nikki's on the road today too. Also, after there's been a lot of travel going on, and Steffi's on the road, but in a good way. She's off vacationing somewhere, so that's a good thing. Yeah, we didn't get a chance to meet last Friday since we were all tied up at Tech Show. So I thought maybe we ought to start there and just kind of share our thoughts about it and what we all thought about it. I don't know, Steve, since you're sort of an officer of the court in a sense, representing Tech Show here, what did you think? What was the what's the party line? What's the official takeaway?
Well, I guess a few points. I thought it went really well. It was very well attended, both in terms of people and exhibitors and sponsors, which was really good to see. I don't have the exact number. I think we were clearly back to pre-COVID days. I don't know whether we surpassed last year. Think that we did, given the numbers that we typically. What happens is you get the people that register in advance, and then there's a big push like the week before because people from Chicago come roaring in at the last minute. That roaring in is maybe the wrong word. So that part was good. There were a lot of really good presentations, I thought, from some really interesting people with different perspectives. The Startup Alley competition was as well attended as I've ever seen it. I think we were in I can't remember. We may have been in the same room last year, but it's a big room. Even the 60 for 60 session, which was on the last day, was very well attended. Next year we'll be moving to McCormick Place, so we'll have a little bit more flexibility with space, particularly exhibit space. I would like to get the Startup Alley participants more visibility. They're kind of stuck back in that little corner down there.
Farther back than they've ever been, I think.
Yeah, which in part reflects the fact that we had a lot of paying customers, I guess is the best way to put it. But which is good and bad. But if I'm back on the board and chair, one of the goals in the new space would be to give them more visibility, because they're really fun to talk to and chat with and kind of see where they're going and what they're doing. We had some overlapping sessions, which is hard not to when like every other conference, most of the sessions are about AI and generative AI. That's something we might work on. But all in all, I would be interested in your all's perspectives. But I was pleased. I thought it went really well. That's the party line. No, I'm just kidding. Those are my perspectives only, and there's no party line that I know of.
Julie, you're there. What did you think?
Yeah, I thought it was a really interesting show in that the conversations I had with people were quite different. I always meet that one or two, solo or small firm practitioner who's like, oh, I'm not really sure what all this is, and this is my first time. And I met a lot of people actually first time Techshow folks. I always look out for them. They're usually actually by the startups, so I would like to hear more visibility of them because I think they find it a little less intimidating to go up against to go and talk to the smaller companies. But the ones that I talked to who were there for the first time, they actually were well educated about what's going on. They said, no, I came here because I know about generative AI. I want to learn more about it. I know that companies are using it more. I'm looking for a company that does X, Y, and Z. I think that's a real big turn for Techshow because I know Techshow's got that audience of people who love this stuff, and we all love this stuff, but also for folks who are just jumping in. And I also met a lot of people who were not lawyers, who serve lawyers, accountants, consultants, um, computer scientists, and that was really interesting to me as well. The panels themselves were very good. Thursday was a blockbuster with Pablo from Case Tax and Joshua Leon, and all the typical guys that I was like, I wish there was more space so that I could go to everything. But it's Techshow for that. But I thought it was really good, and I really think Techshow has really established itself as like the place to have these conversations.
Thank you.
Yeah, I thought Thursday was probably the best attended day of the show. Just when I got there, it definitely seemed like it was almost like a pre-pandemic kind of feel to it. Like lots of people everywhere, mingling about and and things like that. Friday was a little bit less well attended because I from what I understand there was a like an AI like a symposium thing at Northwestern that drew a lot of people away from the show. But I mean that's I mean it doesn't. I think it just kind of shows you just how invested and how interested people are in this topic, and yeah, I think like everyone there, just as we were covering it, I mean, we definitely were kind of like, okay, how many sessions are going to be about generative AI? How many sessions are going to be about ChatGPT and that stuff? But on the other hand, this is what people are talking about. This is what people want to hear about. This is what people are interested in, and it is the technology that people are that's on the top of everyone's mind these days. So I understood that. I mean, it's something that had to be done, and people wanted to talk about it, wanted to learn more about it. And yeah, I think I was definitely surprised at sort of the level of interest in it because I mean, I think I'm sure a lot of people will agree that Techshow, you always get like a very wide spectrum of people who are more advanced, but also people who are there just to like learn about very basic things like how to use Word properly, how to use email, and that kind of stuff. And it seemed like this time it did seem like there was more sophistication at least as far as Gen AI and awareness of those tools and willingness to kind of learn more about them. So that was nice to see.
Yeah.
Yeah, I mean, I think this is the same takeaway I had from Legal Week as well, which is that this is, for whatever reason, the communities we serve, which isn't just lawyers, as Julia's pointed out, there are people kind of in the legal orbit that care about this stuff too. But for whatever reason, generative AI has brought all of those people to a new level of interest that normally the legal community does not have for tech. And yeah, so I saw that at Legal Week. I saw it much more here. I thought that the programming here, like the worst part is obviously we meet with a lot of vendors, which meant I didn't get to see a lot of the actual programming, but scrolling through the actual programming, and I guess Julie touched on this too, that like there were so many panels that were all happening at once that would have all been amazing to have watched. So it's a very interesting time to have the community care this much about the topic.
Yeah, I mean, my own impressions were that it was, um, as Steve said, it seemed to feel like probably the best attended tech show I'd been to in years, and just really good energy around it. And people were excited to be there, and it was in that sense a really good conference. The I have to confess, I don't think I went to like a single program. I was so busy having meetings and whatever else, other than my startup alley, and I don't know, I think there's one other or something I might have made it to. So I can't really comment on the programs. I just looking at the agenda, I was struck by how many there were on AI. Again, reflecting the times, I understand that, but it seemed almost a little bit overkill because a lot of them almost seemed to be redundant in the descriptions. I didn't attend them, so I don't know whether they were redundant in their content, but the descriptions were basically how to use AI in your law practice, and several times on the agenda. But again, I think that's why people are there. I the what the and the startup alley was the same way. I mean, of the 15 companies presenting there, I think all but a couple were some variation on AI. Perhaps telling that the one that won, Alt Fee, is not really an AI based company, or at least it doesn't have AI in its name anywhere. So I don't know what that tells you. Um, the uh, the vendors that I talked to were just like super happy with what they were getting in the exhibit hall. And the startup alley was way in back, and set up in a way where the last four or so of them were like about as far back in the corner as you could get. But I went and talked to every one of those startup alley companies, in the exhibit hall, and even they were saying they're just getting really good conversations, and people coming by with a lot of interest in what they were doing. Um, so I thought it was good. I think one interesting trend with Tech Show has been there. It seems like there are fewer and fewer actual practicing lawyers who go there than it used to be. I mean, I felt like Tech Show was always one of those conferences where there were a high percentage of working lawyers, and not as many kind of industry people or vendors or whatever, other than those exhibiting, but just otherwise. But um, again, some of the feedback I was getting from vendors is they had a lot of people coming to talk to them, but a lot of them were either consultants or working for other companies in the space, and not as many kind of practicing lawyers. I don't know, Steve, if there's any data or anything that would back that up one way or the other, but that was one thing I
Yeah,
kept hearing a lot.
you know, uh, I don't know that there is, and it's really hard to gauge too when people
Right.
sign up. Like we ask, are you a lawyer? But I think we do when you register. But whether you're a practicing lawyer, it's kind of hard to tell. I didn't get that sense. In fact, I actually heard several vendors who told me that, unlike a lot of shows, they actually were getting contracts signed, at the show,
Yeah.
which would suggest they're decision makers there, which typically, for better or worse in law firms, is a lawyer. maybe that's a sad commentary on the business of law, but in any event, so I really don't know. It's hard to say, hard to get that kind of data, but it's something to look out for. Absolutely.
I also heard a bunch of people say that they had signed deals at the show, which I wrote an article several years ago at this point that said that Tech Show was transitioning into being kind of a little bit more of a vendor to vendor show. A lot's more like the buzz I would always hear is more, I built this partnership, we're building that, like we've tested out, I'm seeing what my competitors do, which, there's a place for that too, and it's very valuable too. But yeah, I echo that. I heard more than one vendor say, yeah, we got a few deals signed here, which, is a sign that maybe this is bounding back in that way. I do want to say, I know other people might want to chime in on this, but before it disappears from the chat, I thought Hayden had an interesting question in the audience here about that alt fee thing, and whether or not marketing based on AI is something that is a positive or negative. So I want to table that if people have more, but I think that's an interesting question.
Yeah, I was yeah, I was interested in that too. But I saw that and I started responding, and then a bunch of other people started responding. So I was like, oh, okay. Yeah, no, I thought that was it because I think if anything, from what we've seen, and I mean we've talked about it on this program a little bit, is that there's kind of people are kind of falling over themselves to say that they are using AI and that it is part of their process, or that they are or that they're planning to integrate it into their systems, like some of the big research companies and whatnot. And so I think if anything, people are it's almost become something where you know you want to say you want to say that you're doing it just so that you look like you're keeping up with everybody and that you're not behind the curve and that you're not dropping the ball on anything, that that you're at the very least you know starting to put it into your systems or using it or ready to roll it out at some point or something, just to keep up with the Joneses. I mean at least that's how I see it. But yeah, I'd be curious to see what other people are seeing.
Yeah, I would echo that as well. I had a conversation actually with a practitioner from the Carolinas. I'm trying to remember, I think it's North Carolina, where she was asking about there's a difference, Joe. I know there's a difference between North and South Carolina. Anyway, somebody who used to live in Kentucky, but we were talking about this about AI and what it means when people market themselves as AI. And I know we're not into the startup alley discussion yet, but I kind of
We
love
can
all.
talk about it. We're going to merge it all together. It's good.
Okay, good. Because I'm really happy about Alt3 winning, not just because they're a Canadian company, but also I think this is really one of those trends that isn't going to let go. That AI is accelerating, which is subscription fees and alternative flat fees, right? Which has been around for quite a while. But as we're talking about efficiencies and moving data into generative AI to find those, all those wonderful things, you're going to need a system like an alt fee. This is not me promoting alt fee. I'm just saying what they're talking about makes a lot of sense. And so I kind of feel like people talking about AI is the same way where I, get my cable and phone if I'm inclined to not be a cord cutter and they bundle my services, am I gonna get unlimited data on my cell phone when I get a package. It's kind of just part of the pitch. And if I don't mention AI when I'm selling my product or service, the customer is going to ask at some point. And I've heard this from other lawyers as well, from clients and vendors, where if they don't bring up AI, they bring up AI first. And so I think it's just part of the normal vernacular of legal tech at this point. But I do think what AltFi did is bridge that together, even though they're not saying we're a generative AI company. They're really selling about flat fees and subscription. But I think they made that link, and it was smart of them to do that when they were doing their pitch.
AI adjacent, I guess. Yeah, I think. I mean, I think obviously every company in the world seems to think it's to their benefit to market some variation on AI in their product. I think it's also interesting how many companies are now going to pains to point out the differences between when they're in some ways developing their own AI. There was one of the startup alley was developing their own large language model for legal. Which one was that? Was that
There were a couple.
like
Yeah, because
yeah, there were a couple, yeah.
I noticed that too. I was like, oh, they're yeah, because they made a big deal about how they were developing their own proprietary
Yeah.
language as
It might have
opposed to
been
just relying
Paxton,
on
maybe.
OpenAI. Yeah,
Paxton might have been
I
the
think one of the first. I think the first two or three people.
yeah.
I'll have to go back and take a look at my notes.
Paxton was the first one to go up, and I think that was part of their pitch. Um, and then also at the same time pointing out, when somebody else is really just building a integration with ChatGPT or something and not doing anything all that phenomenal. Um, I had a point that I was leading to, and I totally forgot what it was. Um, but what I was going to say, I mean, regarding, you know, I think it's important for people starting up legal tech companies even to remember that there are a whole bunch of problems that lawyers still have that don't need AI to solve them. And if we all focus too much on AI, maybe they're missing some opportunities to address other opportunities that still exist in the legal space. What's the other thing on Techshow? Anything else on Techshow? That's
Well, one thing I thought was interesting is that like kind of like to build off the alt fee thing. There were a couple sessions where, and I think also they talked about this in one of the, I think one of the main presentations, talking about how this could be the end of the billable hour. I thought that was also kind of a recurring theme with some of these presentations, and I don't know. I mean, I understand the optimism and I understand the impulse for people, but you know, the billable hour to me is kind of like the Terminator. Like you can't kill it. Like it's been here forever, and I'm well, not forever, but like it's been here for so long, and so many things have come up that have threatened it, and they've batted it aside. So I mean, look, I mean, could this be the thing that does it? Maybe, but I wouldn't invest all of my money in that. You know.
yeah. I mean, going. Although again, that's part of, as I think Julia pointed out, that's kind of alt fee's pitch in a sense, is that the billable hour just doesn't work anymore in the age of AI, and that's why you need something like alt fee to help you set your fees more rationally based on factors other than how many hours you spend on it. All right. Well, Steve, we'll be looking forward to bigger, better. Should you get the honors next year? You're gonna have more space to fill, right? It's gonna have to be bigger. Is that
Yeah,
the
that place is
idea?
huge.
It is huge,
That
but
place is huge,
I'm
and it's not honestly like I feel like most people are like it's not as fun down there. Like it's not that close to downtown. It's close to like Soldier Field and like those areas. And like there's stuff to do around there, but yeah, like for the people who want to like go to the good restaurants in the Loop, or want to they're gonna have to drive or take an Uber or something. I mean it's not the best area to be as far as like eating and meeting up and stuff like that. So that and for us locals, it's especially those of us that live in the north, not going to be fun getting there.
No, but
right.
Victor, it is close to the Shedd Aquarium. We'll be closer to the Shedd Aquarium, which is one of the
Yeah,
best
Soon.
aquariums
it
in
is.
the
It
world.
is.
So
It is.
there's the selling point for McCormick Place.
And if the
Yes,
Bears move away, then there'll be lots of parking space around the stadium that we can use.
I do have a
yeah,
new
it's
favorite restaurant in Chicago now, thanks to Joshua Lennon, who introduced me to it there. And I'm already blanking on the name of it, but Joshua may remember, he's in the chat. But have a Mexican place, but it was really, really good. I'm sorry,
although
Steve.
I have to say I went to several restaurants while I was there, and probably because it was sort of cold and windy, I took an Uber to every one of them. So
Right. Yeah.
one of the people I was with one of the people that we all know on this show had an Uber allowance that was needed to be spent.
Ah, yes. Frontera Squirrel. Yes, thank you, Joshua. That was an excellent place. If you're ever back in Chicago, I highly recommend it. Really good.
Yeah. He's the good Bayless brother. You should always support him because he doesn't talk to Skip, I believe. I think they like are very estranged. No, they really are brothers. And
Oh, they really are. I
yeah,
didn't know
yeah,
that.
yeah, no. Yeah, no, he
Oh,
and yeah, they do not get along from what I gather.
hmm.
And they
Well,
went to high
how
school
can you
with
get along with Skip?
I know, right? And they went to high school with Elizabeth Warren. It was like the three of them like in a row, like 1 year apart or something like that. It's like really wild how that random Oklahoma school produced all that.
All right. Well, another week, another two examples this week of hallucinated cases getting filed in court. I wrote them about them on my blog. I think some others might have covered them as well. But interesting. Both cases in which hallucinated cases were filed, both cases that ended up resulting in sanctions. The interesting difference between the two of them is that in one of them it was a pro se litigant who was filing an appeal, self-represented on an appeal, but filed a brief in which, what was it, 23 out of 25 citations were made up or something like that. And the when questioned about it, or when the court raised it with the self-represented litigant, the litigant essentially said they had hired a lawyer online who claimed to be admitted in California and had written the brief for them for some fraction of the cost it would have cost them to hire a real lawyer. So we don't know whether there's actually a lawyer behind the story or not. But this self-represented litigant got a pretty steep sanction, I think. Got the appeal dismissed and then got a $10,000 order to pay $10,000 in attorney's fees toward the other side's defense of the matter. Then in the other case out of Massachusetts, where a lawyer actually filed several responses to motions to dismiss in a trial level matter. Turned out the judge was looking at these motions, at these replies rather, and kind of got suspicious. They didn't just quite look right, and started looking them up and realizing that several of these citations were fiction. They had a hearing on the motion to dismiss when the judge confronted the lawyer about it. The lawyer was as surprised apparently as the judge was and didn't seem to have realized this, but then the judge asked the lawyer to go back and figure it out and write a letter explaining what happened. And so the lawyer basically threw his staff under the bus insofar as blaming two recent law school graduates working in his office and an associate working in his office who apparently had used this AI thing to help write these motions, whereas the self-represented litigant had to pay $10,000 for their fictionalized cases. The fellow brethren of the bar here, I guess, only had to pay $2,000. I think pretty much got off kind of easy in this case. The lawyer basically just professed, ignorance of AI, and apparently admitted that although he had reviewed the memoranda for style and grammar and stuff like that, it never bothered to check the citations. But I thought it was important. I thought what was probably most interesting about that decision was the kind of broader lesson that the judge ended the opinion with, and basically saying that it is imperative that all attorneys practicing in the courts of this Commonwealth understand they're obligated to know whether AI technology is being used in the preparation of court papers, and to ensure that appropriate steps are being taken to verify the truthfulness and accuracy of any AI-generated content. Then he goes on to say, the blind acceptance of AI-generated content by attorneys undoubtedly will lead to other sanction hearings in the future, but a defense based on ignorance will be less credible and likely less successful as the dangers associated with the use of generative AI becomes more widely known. So lawyers, you're on notice, I guess.
But here's what I don't understand. Like if I had used ChatGPT and but then checked all the citations, then how would they know I used it? Like,
as long as if you check the citations and they're real, you're fine, right? What's it matter?
How would they know? How would they know how I prepared it?
Right, and that's the problem with some of these rules, like that Texas rule. That's all like you have to disclose that you used it at any part of the process. It's like, well, why? If I got the cases that way and I checked that they're right, why do I have to tell you what the guts of the search were? Especially,
well, he's not saying though that this judge wasn't saying you had to say
Correct.
that you used AI. He's just saying check it, verify it.
Right. Now, yeah, I was transitioning a little bit to the Texas situation.
Yeah.
I don't, the thing I don't understand about that, and maybe there's, like a lot of cases like this, there's more that may have gone on that is not known, but why the pro se litigant was treated so harshly. I don't get that unless, maybe, as I say, maybe there was something more that went on in the case that the judge was aware of that aggravated him or her. But to charge us is basically saying to a pro se litigant, you should know and understand the risks and benefits of this technology. When how can you expect that? It's almost like saying if you use a chatbot to book your flight and the chatbot's wrong, you should have understood and known that.
Right, right. We'll get to that.
But
Um,
but yeah. I read that your story, Bob, and I couldn't. I just, it was somewhat remarkable. The other thing I
yeah,
thought was
I should
that
just on that point. I should just say I skipped over in my story. This self-represented litigant had also just had made a mess of their filing and had screwed up in multiple ways in terms of filing this appeal, and the judge had kept giving him extensions to fix it, and he didn't fix it. And I think ultimately the judge thought this was just an entirely frivolous appeal that was wasting everybody's time in the first place for other reasons besides just the. So there might have been other reasons contributing to that
yeah,
$10,000.
that's what I wondered as well. The other thing it's kind of hits me. It seems to be happening so often. I mean, it's you know, I wonder if it's just a temptation for busy lawyers who think, well, I'll just use the citation. Nobody will probably check, and I'll be okay. It's probably not much risk. And that's that complacency danger that that is beginning to become kind of worrisome.
Yeah, yeah.
Yeah, all these cases worry me because we just talked about a tech show where we said we saw people who were more sophisticated about this. And then people do these things like, I mean, you can't turn in work without looking at it first. And from what I've read there in your blog post, Bob, like some of them, XYZ company, it's like obvious. But I was worried about the pro se litigant because we did have a case like that in Canada recently. We've had two recently. One where there was a pro se litigant who also used AI, and the judge said don't do that again, but didn't find them. And then a lawyer who did the same thing that you were mentioning, where they turned something in and it was obvious that the cases were fake. And I just don't know if there's proper training, or training is really the common sense part of it, right? But I just don't understand what's happening in those lawyers' worlds. Like, how does that firm operate? Because if this is happening, what else is happening in that firm? And I'm not trying to say all these lawyers are practicing in unethical ways. I'm not trying to say that at all. But this one, it's pretty obvious. The vast majority of the cases, almost all of them, were fake. So a paralegal, a legal assistant, a law student, a first year associate couldn't have caught any of those.
Yeah, I mean, that's to Joy's. Joy's made the point in the chat. Joy wrote Heath Rush,
Does that law firm
and
have
we've
that
said
in
it on
place?
this.
Yeah.
Yeah, we've said it before. This is not technology's problem. This is sloppy lawyering. That's what it comes down to. And
Yeah, of course, for years lawyers have, I say, cut corners is maybe too strong of a word, but they would rely on Westlaw head notes, not to pick on Westlaw, and those aren't always accurate, or at least accurate to fit in within a particular factual situation. Now, I realize that's different than citing a fictitious case, but I mean, I could many times I would plug cases into briefs that I had not read the cases. The associate had done the research, or there were times where you would have the standard for summary judgment in this jurisdiction is whatever it is, and you'd have cite 4 or 5 cases. I never read those stupid cases. I just assumed they stood for what they stood for, and it was never challenged on it. But there's that sort of temptation, I think, with the ChatGPT kind of tools for people to treat those sort of the situations the same way, and they're not the same.
yeah. So before we get to your chatbot, Steve, there was a related sort of related ChatGPT case or situation this week that Joe that you wrote about. I mean, not a hallucinated case, but a reliance on ChatGPT that didn't go over so well.
Yeah, so I knew that we were going to have more conversations about hallucinating case law, so I thought we'd shake it up a little bit. In the Southern District of New York, there was a case where Judge Engelmeyer got very annoyed with a law firm that had used, in fairness, not exclusively, and transparently they used it, but had used among their sources when they were seeking, they had won an idea statute case, which entitles them to reasonable attorney fees. And in proving reasonability, they cited a number of sources, and one of the sources was a ChatGPT search, which their argument here, the judge dismissed this out of hand and wrote a little bit of a diatribe about how utilizing ChatGPT was utterly useless and unpersuasive, the rare multiple U alliteration. But his argument, the argument of the firm, which I thought was very interesting, was, look, increasingly AI is part of our lives, and the reasonableness of hiring an attorney is going to be determined by regular folks typing into something like ChatGPT, how much does it cost to hire a lawyer to pursue XYZ thing in New York City? And it's going to give an answer, and that's what they're going to assume reasonability is, which I thought was a non-ridiculous argument. Now, the flip side of this, of course, is that the other sources that they had cited were a series of reports that did stuff like lump Cravath's, what Cravath charges folks to, charges Goldman Sachs to pursue a case. And they were saying, yeah, I mean, that's what New York charges, which is probably different than an administrative hearing. And the judge thought that was very irritated by those. And by extension, what ChatGPT probably does is look at those exact same things that the judge said were already the wrong sources and spit that back. So it was useless, but I was struck that he didn't really zero in on the idea that it was going to just regurgitate the same sources that they'd already decided were wrong. He went off on hallucinations, which bothered me because I think this is a situation where it was not hallucinating. It didn't seem. It seems like it was giving very real answers that were wrong, but they were real. They were based on stuff, based on real data, like these real reports. They were inapt for the situation. That didn't make them any less real. And when the judge's only argument was to explain hallucinations, it bugged me because I worry hallucinations, I think, are going to be, at least in the legal space, going to cease to be the problem with AI relatively quickly. We're going to start building things that deal with that problem. What's going to be the problem is the reliability of the data that goes into it, these, as far as whether or not it's good for the process. And the fact that a judge is hung up in a case where there probably wasn't a hallucination, is hung up on the hallucination idea, bugs me, because I feel like it's a sign that we're not ready for prime time when the next turn happens.
It bothered me too, Joe, and basically for the same reason. I mean, the real issue was, whether the fee was reasonable for the type of work being done in the locale where it was being done, and that's what the ethical rule says that the fee should be based on. But as I understand it, in these ADA cases, it's the loser pays. I mean, if you're the defendant, which I suspect is what the law firm was thinking. Oh, yeah, well, XYZ company is going to pay the fee, and maybe we can just bump it up a little bit by using these examples. Whichever it was, the reasoning of the court was focused on the wrong thing. Right result, wrong focus.
Well, and here's the thing, right? I mean, like, I was also troubled by this, and partly is because, okay, so I think maybe they're focusing a little too much on the ChatGPT part. Like, what if they just use like a regular analytics program to help them crunch the numbers and say, okay, well, typically in these type of cases with this type of result, this type of scenario, this is the fee that typically comes in when it's this much time is spent on, and I mean that's an AI tool as well. So like, what if they'd use that kind of a program instead of typing it in ChatGPT and being like, hey, what's the reasonable fee for blah blah blah? I mean, would they have still come to the same conclusion? I don't know.
Yeah, I was going to ask you this question, Joe, but I think you've cleared it up, because when I first read it, I was like, I don't understand why we're talking about hallucinations. and the firm actually used other sources. Now, as folks are talking about in the chat, perhaps that is not the best sources that they should have used, but I also don't want people to conflate bad generative AI decisions or information as hallucinations. Those are two completely different things. Hallucinations it's fake, it's not real data, whereas generative AI is known to give really bad data, right? Because of the inputs that it's given. And really, like you said, a better conversation would be, does it have the information it needs to actually identify how much you should be charging for legal fees? That's a totally different conversation that people are working on, as Joshua's, posting what Clio does. So I'm worried that judges are conflating bad AI equals hallucinations, because that's gonna give us a step back. I think we're actually doing really good in terms of understanding AI, understanding how Gen AI works. Like, I actually think the legal industry is doing well in adopting this technology. I just don't want us to take a step back and start going off about things that aren't the same, because we're doing so well.
Yeah. There's been a whole lot of sort of discussion in the chat about the difference, the sort of two sides. There's the hallucinations on one side, but then there's what happens when the output is maybe just wrong, not hallucinated, but maybe gives you the wrong result, or a case that's been overruled or something like that. And that sort of seems a little bit relevant to Victor, to the story that you wanted to highlight this week about how to write, how to talk to ChatGPT in the first place. And
Yeah.
okay.
So yeah, we recently hired a new reporter, Danielle Braff, and this is one of her first stories, and so I thought I'd highlight it here. But yeah, basically, and I mean, and one thing that we've been hearing about, just, and we talked about on this program too, is just like, one possible area for lawyers or legal professionals or whatnot, if they want to either differentiate themselves when they get out to the market, or maybe make themselves more attractive to, like, for jobs and whatnot, is to learn how to phrase the search terms properly for generative AI tools, ChatGPT tools, and whatnot. And so this article kind of takes you through sort of like, like from people who have been playing around with it, and kind of give some tips to sort of like how to properly phrase these search terms, so that you'll still get the occasional hallucination, or the occasional thing that you have to double check and whatnot. But there are ways that you can structure your search terms so that you're not so you can limit that. So I actually, and ends up being the case where sometimes you have to end up doing quite a lot of work and a lot of research to phrase your search term properly. So you're not just saying, hey, ChatGPT, give me all these cases about such and such. You have to kind of explain, okay, this is what I want. These are the facts of the case. This is this is the state, or the venue that's the jurisdiction that's relevant. Give me these types of cases and whatnot, from this to this. So it ends up being a pretty involved it ends up being a pretty involved process. It's not just just typing it in and there you go. So obviously it still beats going on doing all the work yourself, or starting from scratch and whatnot. I mean, you still save time that way, but it's not like you just type in a few words and boom, there you go. So I think and that kind of ties into what we've been talking about in general, just this idea of needing to be a little bit more careful, a little bit more thorough, a little bit more, not just take the really, really quick shortcut, but maybe take like the not so shortcut. It's still a shortcut, but it's not gonna save you like tons of like as much time as maybe you thought it would, but it'll still save you time, and it'll save you a lot of headache down the road. So that's sort of what the story was about. Feel free to check it out, and as always, criticism or comments, you can send them to my dog.
Will will the dog hallucinate?
Well, see, this week she was kind of a dingus. She ate a very large, I guess what's the legal term? A not insignificant portion of my carpet upstairs. So we had to take her to the vet and get it taken out. That was not fun.
So, this actually reminds me, this was a conversation I had at Legal Week with the folks from Redgrave Data, that what a lot of people don't understand is that a lot of these LLMs, they consider different parts of the prompt and give weight to different areas of the prompt. And that's something that is kind of black boxed, and they're running tests, and a lot of people are, I guess, to figure out like, hey, what is it that actually gets this one to do something? And unfortunately, as it's training itself, sometimes it's changing its approach as it goes. And so figuring out even how to write a good prompt is a whole thing at this point, which is why I have my new startup, Promptify. If no one's heard about it, I'm seeking somebody to buy it. It's a one-click solution. It's optimized. Lawyers just hit a button and it will create a prompt. It will create a prompt that will give you actionable results. Now, it will have nothing to do with anything you're interested in, but that's not the point. Point is, the prompt will deliver results, and I think Litera should buy it.
Maybe
invest.
Thomson Reuters will buy it. They seem to be.
Oh yeah, Thomson Reuters. Yeah, Thomson Reuters has some cash. Come on.
I was gonna say Thomson Reuters will be calling you, or maybe even texting you right now, or using ChatGPT to work out the details of the deal. I really like the article actually, Victor. I'm working on an article right now of a professor who's trying to develop a course on prompt engineering for law students, and he also equated it to back in the day when we had legal search tools first come out, and we had no idea how to search for cases and search for legislation using those tools, and how we had to kind of get muscle memory to learn how to do that with Westlaw and all these other tools. And so I actually like the suggestions in this article just to kind of think it through 1, 2, 3. So,
Of course, it's, we probably always needed training for the senior partner giving an assignment to a young associate that was so I can remember walking out of some of those assignments going, what the hell is he talking about?
Well, it's kind of the opposite for Lexus or Westlaw or even Google. It's like the more you put in, like the fewer things you get, because like if you overload your search terms, then it's almost like, no, well, we're not like, how many documents are going to have all those words in it that could possibly be relevant, like, so so yeah, it's sort of the opposite of that, where it's like, rather than putting in a few search terms and then kind of calling the result, it's like you put in a large search term to kind of narrow down what all the stuff that you can get. So I can see why it would be an adjustment. I mean, yeah, like just someone, Dennis brought the Boolean searches. I'm like, yeah, like that takes me back to law school in a bad way.
Well, maybe OpenAI should set up like a chat interface. Like it's good when companies have chat interfaces that customers can come to and ask questions and get answers. Isn't that right, Steve? Or no?
Yeah, I think so. just don't rely too much on the answer.
Yeah. That was your cue.
Oh, sorry, I missed it. So there was Air Canada, in honor of our guest from Canada, probably gets the prize for dumbest argument of the week when it comes to, so there's this person whose grandmother died, and he wanted to get, I think it was he wanted to get a bereavement fare. So he went to the website, and there was a Air Canada chatbot, and he asked the chatbot about it, and was told, pay full fare and you will get a refund afterwards. So he paid full fare, happily thinking he was going to get the refund. And when he went to get the refund, customer service said, oh, sorry, no refund. You have to purchase it. You get the refund before. You can't ask for it. You have to purchase the discounted ticket before. You can't ask for a refund afterwards. And he said,
wait, slow down. So let me get this straight. A Canadian said sorry. I just want to make sure I got
that. Yes, actually, it probably wasn't sorry. It was probably more like, you dumb whatever. You shouldn't have relied upon our chatbot. What were you thinking? And the passenger then filed the claim in small claims court, and the argument that was made by Air Canada was just that the chatbot is a separate thing. We can't control what it says. You shouldn't have relied upon it, and therefore you lose. Which which really is a pretty dumb argument. I'm not exactly sure why they would have made that argument. Perhaps it was a person in the customer service department of Air Canada who thought this sounded pretty good, and maybe they thought this would bluff the passenger away from making a claim or filing in small claims court.
Maybe they asked
Maybe
ChatGPT how to
I
respond.
was just going to say that. Maybe they asked
and to be
ChatGPT,
fair,
but the
and to
go
be
ahead.
fair, like there's a former president of the United States who has made that same argument. So
that is true. Perhaps the better argument would have been, you should have known that these things hallucinate. Our chatbot hallucinates, and you should have known that it hallucinated and shouldn't have relied upon it, which I think is also maybe a dumb argument. But I frequently encountered when I was practicing law, much more than I am now, that lawyers would sometimes make dumb arguments and file dumb pleadings in a sort of a rote way, not thinking about the public relations angle of what could happen. I was in a case with several people who were killed due to a horrific accident, and contributory negligence was pled, and which was a knee-jerk reaction, but the public reaction to that against the lawyer's client was horrible. And so, this is a black eye for Air Canada. The argument is so stupid and so bogus that why anybody would make it is almost beyond comprehension. But so it just could have been the knee-jerk sort of let's plead anything and hope it sticks, which and often comes back to haunt.
Yeah, I will say as the resident Canadian here, we are not surprised that they have made the dumbest legal argument or made themselves look stupid in this country. We are quite accustomed to it. I haven't also seen anything to say that this chatbot is even AI enabled. It's been there for quite a long time as somebody who has also used the chatbot before, though perhaps I should be using it more in a way where I can sue them and get compensation. I just don't understand this case at all. And so folks should know Air Canada has been sued successfully in small claims before in BC at the civil tribunal. So them losing again in small claims is no surprise. There's actually some articles here talking about how Air Canada keeps losing and how customers have to keep going to small claims instead of using the legislation and the other government body to actually supposed to take care of this. There's supposed to be an administrative way to take care of this, but they're not able to, so they have to go to small claims where they know they have a better chance of winning anyway and getting the money sooner because Air Canada sucks that much. But
it was so weird because they try to claim it's a separate legal entity, and I was like, you can't like retroactively do that. Like maybe you create it as a separate legal entity beforehand, and then we have a corporate veil conversation. But like you can't retroactively pretend that it is. And I read the order, and it didn't seem like Air Canada even tried to claim that they had proactively done that. They just kind of said, it was so wild.
I guess in some fairness, the report that I read said that the chatbot did indicate that you needed to check the website, and the correct information was on the website. I don't know how conspicuous that was, nor do I know whether the chatbot said, the information I'm giving you could be wrong, so you better go check it. It would be, I guess, a semi-plausible argument to say, that you needed to check what the chatbot said because we say on the face of it, it could not be right. That seems kind of silly, but it's not as laughable as saying the chatbot was a separate legal entity, and we have no control over it. I mean, it sort of strikes me as the dog ate my homework, or I guess in Victor's case, the dog ate my carpet. Excuse.
But that really happened.
Yeah, you can't retroactively create an entity and pump liability over to it and leave it judgment proof unless you're in the United States and you're trying to get rid of asbestos claims or something. But everywhere else in the universe, you have to do that beforehand. It was so weird.
And there is actually a lesson for lawyers in this story, I guess, because a whole lot of law firms have chatbots on their sites, and there have been several ethics opinions that talk about the fact that
Right.
if lawyers are going to be having chatbots on their sites, they better be damn sure those chatbots are giving out, if to the extent they're giving out information or whatever else they're doing, that they're accurate in what they're doing. And
You know how why I have no concern about that? I don't see a single lawyer having a chat bot whose customer service advice is going to be, here's a legal thing you can do without us billing you. Everything that they're going to have is going to go to that. Like the idea that it's going to be like, you know what, instead of us billing you, here's an answer, don't worry about it, is not something that's going to happen.
right,
But
I
you know,
think the greater
let's
concern is
pause.
more that they create an attorney-client relationship in some way, or
Yeah.
lead the person going through the chatbot to think they've created a relationship. Sorry, Victor.
Sorry, but like, let's give it up for the chatbot though. That chatbot showed more compassion and more care for that grieving man than Air Canada did. So let's, maybe they aren't so bad after all.
Yeah.
That's very true. Let's shout out to the chatbot. And also a little tip, if law firms are going to use chatbots, make sure it's connected to a human person as well, somebody who's actually monitoring what's happening in the chatbot. Air Canada could have contacted that person at any time if they were actually monitoring this thing. So, but if they weren't, then the chatbot really was its own person, having its own feelings, having its own kind of day when all of this happened. But yeah, if you're going to have a chatbot, have a human person connected to it.
And stay away from Air Canada. All right, we are out of time. Appreciate everybody's input today. Appreciate everybody in the chat participating. Everybody who watches it. Julie, thanks for sitting in. Really appreciate your thoughts and insights. And we'll be back next week. Everybody have a good week.
Thanks, everyone.